Traffic stops, routine for officers, unnerving for many. But what happens when misunderstandings spiral into chaos? Today, we examine a tense encounter between a motorist and police, dissecting the legality, communication breakdowns, and rights involved. Stick around as we analyze what went wrong and what could have been done better.
What? I just pulled out from my crib.
Can you have a seat to the car?
No, what do y'all want? Y'all finna piss me off. I just, how the fuck y'all gonna sit on my block and y'all see me pull out of my house to get gas?
I don't know what you're talking about, miss.
I just seen you on Rosedale. I stay on 212 North Rosedale.
Okay. I don't know that.
You just seen me pull out of my driveway. You was sitting right there. Why was you sitting on my block? And then you waited for me to pull out.
Is it illegal for me to sit on your block?
It's illegal for you to just pull me. What was the reason?
When did it become your block?
But you didn't tell me what reason why you just pulled on my plate because it's a tip plate and I just bought this car.
I haven't been able to talk
What's
to you.
The reason? What's the reason?
You don't have your seatbelt when you drive.
I did just have my seatbelt on.
Okay.
At this point, the driver is visibly frustrated, asking why they were stopped. The officer cites a seatbelt violation, a common infraction. Under 42 U.S.C. Section 1983, officers must establish probable cause for a traffic stop. While a seatbelt violation qualifies as probable cause, this moment sets the tone for escalating tension. Could clearer communication here have prevented what follows? Absolutely. Breakdown. What happened? The motorist disputes the reason for the stop, claiming they had the seatbelt on and removed it after pulling over. Analysis. The officer has a legal right to initiate a stop for a visible infraction like a seatbelt issue. However, failing to articulate the stop's purpose early can escalate distrust, as seen here. Communication is key. A concise explanation could de-escalate confusion.
I have my seatbelt on. No, I have to go to work or they're gonna fire me. No, I'm not gonna do this with you.
Driving license, proof insurance, we'll get you on your way.
I'm not doing this with y'all.
Can I please have your driving license?
Stop talking to me. Stop talking to me. Stop talking to me. Stop talking to me. I have to call my mom. Please stop talking to me.
This moment is critical. The driver refuses to provide identification and requests to call their mother instead. Under Terry v. Ohio, 1968, officers can ask for identification during a lawful stop. Refusal to comply can lead to obstruction charges under most state laws, including statutes like 18 U.S.C. Section 1510. Here, the refusal adds another layer of complexity. Breakdown. What happened? The motorist insists on calling a parent instead of providing documents. Analysis. The motorist's decision to delay compliance risks obstruction charges, which are legally valid in this context. Calling a third party during a traffic stop isn't illegal, but it doesn't excuse non-compliance. Officers should reiterate legal obligations calmly and offer a structured opportunity for compliance.
Ask you one last time.
Okay,
If you refuse
what?
okay, you're gonna be placed under arrest. Last time, are you gonna give me your driver's license, proof insurance, or are you gonna be placed under arrest? Last question.
Why? You didn't ask me a question.
You're under arrest.
You didn't ask me. I'll give it to you. Get out. I'll give it to you. Get out.
As officers escalate to removing the driver from the vehicle, we see physical resistance. Under Pennsylvania v. Mims, 1977, officers can order drivers out of vehicles during traffic stops for officer safety. However, the use of force must align with Graham v. Connor, 1989, which mandates that force be reasonable and proportionate to the threat. Legal justification 8/10 white heavy checkmark. The officer had valid legal grounds for the stop, citing a seatbelt violation. The probable cause was established, aligning with 42 U.S.C. Section 1983 and traffic enforcement standards. However, the rating is not perfect because more explicit communication about the cause could have bolstered the officer's position. Officer communication 5/10 warning. While the officer did provide the reason for the stop, the tone and clarity were lacking, leading to escalating confusion. Communication plays a pivotal role in de-escalation, and clearer language could have prevented tension. This mid-level score reflects the officer's adherence to protocol but highlights a need for better soft skills. Motorist compliance 3/10 triangular flag. The motorist failed to comply with lawful requests, including providing license and registration, which is required under Terry v. Ohio, 1968. While fear or confusion can explain hesitation, outright refusal significantly complicates the encounter and justifies the low score. De-escalation techniques 4/10 fire. The officer escalated to physical removal when verbal de-escalation could have been further attempted. While Pennsylvania v. Mims, 1977, supports the officer's ability to order the driver out of the car, the situation could have been handled more diplomatically. The rating reflects adherence to legal standards but critiques the missed opportunity for less confrontational approaches. These scores highlight how both parties contributed to the escalating tension. The officer's legal basis was strong, but communication issues and a lack of de-escalation strategies detracted from their performance. Similarly, the motorist's failure to comply undermined their position and escalated the situation unnecessarily. This balanced approach ensures a fair critique while providing constructive takeaways for both law enforcement and the public.